You're listening to podcasts from the Congressional Internet Caucus Academy.
Moderating the discussion today is Yaja Pierce from Covington and Burling, and she's also an Internet Law and Policy Foundry Fellow. Our panelists are Dan Schweitzer from the National Association of Attorneys General, Michelle Richardson from the Center for Democracy and Technology, Evie Eastman from the Arlington County Commonwealth Attorney's Office, and David Lieber from Google. So, Yaja, take it away.
Well, thank you all so much for coming, and thank you to the Congressional Internet Caucus for hosting. This is obviously a very interesting case to dissect, and I know that we have a good mix of lawyers and non-lawyers in this room, so we're going to try to break this case down in the limited amount of time that we have, and hopefully leave about 15 minutes or so at the end for questions. So first and foremost, a bit of background on the holding of this case. Justice Roberts wrote the majority opinion for this case, and the holding was in two parts. The first part was that the government's acquisition of the defendant Carpenter's cell site location information, CSLI, which is kind of a messy acronym, was a search under the Fourth Amendment. What is important under this finding is that it did not extend what is known as the third-party doctrine, which is embodied by cases starting with U.S. v. Miller and Smith v. Maryland. The third-party doctrine essentially means that you have a diminished expectation of privacy when you give your information to a third party. The second part of the holding is that because this was a search under the Fourth Amendment, a warrant based on probable cause was required to obtain this type of data. So for the majority, we had Justices Roberts, Kagan, Sotomayor, Ginsburg, and Breyer. And for the dissent, we have all writing separate dissents, Thomas, Alito, Gorsuch, and Kennedy, which we will be talking about the implications of towards the end. So what I want to do is start off by actually forgetting that the Carpenter opinion happened and have each of you tell me what the status quo was like before this case was decided. So first, I guess I would like to start with Dan and Evie and ask, pre-Carpenter, what was required to obtain cell site location information?
If you want to start, since you actually did it.
Certainly. Hello, I'm Evie Eastman, just across the river in Arlington. We generally, when we wanted to get anything resembling cell site location in Virginia, the Electronic Communications Privacy Act, the Stored Communications Act at the time, allowed us to get historical information that in the past through the use of a court order with judicial approval. And we would prepare an order based on an affidavit prepared by the police officer, and then we would approach a judge of our circuit court and ask the court to enter the order, which we would then promptly send to the cellular phone provider. Some years ago, a case came through the Fourth Circuit that seemed to suggest that we might need something more than a court order for cell site information. So probably about 6 or 7 years ago, maybe longer than that, in Arlington at least, we started preparing court orders based on probable cause and getting judicial approval for that, for cellular site information. So we did things a little bit different in anticipation of what is now the law through Carpenter. But if we wanted cell site information at the time, we could have gotten it through what's called under federal law 2703D order under the Stored Communications Act and gotten the information that way. Police officers were very familiar with going down to our magistrate, because in Virginia we have a magistrate system as well as a circuit court system, and they could have gotten a search warrant for the same information either from a magistrate or from one of our circuit court judges. Now they only do that exclusively through the circuit court.
And if we could really quickly get a perspective of what this pre-Carpenter world was like from a privacy and civil liberties standpoint, as well as from a big tech standpoint from David, that would be great too.
Sure. You know, we were in a world where the third-party doctrine was really happening any sort of development here in the legal world of what privacy would look like in the modern day. And over the last 15 years, we'd had occasional wins, more recently on cell phone tracking and the information in the cell phone. But underlying it was this idea that sharing information with someone you were contracting with to actually offer you a service and process your information actually destroyed any privacy in it. And it was not workable for 2018, probably wasn't workable 20 years ago. And what we saw was because there was so little movement on a federal level, states started to act. So I think there's now 12 states that had some sort of warrant protection for location data in the U.S. Most of that was through state legislatures, although there might have been a couple that were through the state constitutions. And it followed on a number of efforts to tackle this issue by issue. And it's interesting to see that that will continue now that we have more of a legal theory going forward, that we're not going to be taking on the third-party doctrine altogether probably over the long term, but we're going to have to look at unique types of data collection and technology and the threats that they each pose.
David, pre-Carpenter world?
Yeah, I think there's always been some ambiguity about how courts would look at the third-party doctrine, and the Smith and Miller cases, which were decided in the 70s, how they would be applied to in light of technological innovation. And I think what we've seen over time, at least, is courts sort of make traditional distinctions between content and non-content. In 2010, the Sixth Circuit decided a case, United States versus Warshak, where they effectively opined that to the extent the Stored Communications Act does not require a warrant for content, that the statute is unconstitutional. And so there's been a little bit of incremental chipping away at this third-party doctrine, but there's been a lot of questions about the extent to which the third-party doctrine maintains its vibrancy in light of technological innovation and in circumstances where transactional data was being transmitted to third-party service providers or stored on third-party platforms. And so in a pre-Carpenter state, there were some questions about the extent to which the Fourth Amendment would extend to that type of transactional data. And that's certainly a question the Carpenter Court answered in one particular set of circumstances.
Great. So now we're in a post-Carpenter world, and I'd like to talk about what it means for each of your perspectives.
So I'll start on that. I think from state prosecutors' perspective, it's a mixed bag. I mean, it was a loss. We started the day before Carpenter was issued. The law in most of the country was that we didn't need a search warrant to be able to obtain cell site information. Now we do if it's over a week or over. So what that does, and Evie can sort of confirm this for me, is it's going to make it harder to do some criminal investigations. There are some investigations where you don't have probable cause yet, but you have a suspect, and the cell site information will help you really pinpoint whether that suspect really is your guy, because you get that information that they were using their phone around the place of the robberies. There are crimes, Justice Kennedy listed in his opinion, serial killers, arsonists, certain robbery sprees, certain drug crimes where they take place in multiple sites, and this information really is helpful to the investigation. So it is a loss to the government that they can no longer obtain this information without a probable cause-based warrant. Now, there's not necessarily a huge number of cases affected. Someone from Queens County, New York, a very large county, said that out of 54,000 prosecutions in 2016, 92 of them used cell site information. And of course, how significant a loss will be depends on what other technologies are affected, and we're going to, talk about that a little later. But it could have been a much more damaging loss. So the court took pains to say it was not getting rid of the third-party doctrine, and so not taking away the government's ability to subpoena banking records, credit card records, other financial records. That's really the bread and butter of government investigations into tax evasion, bank fraud, a lot of drug crimes, and the like. The court said it wasn't calling into question what it called conventional surveillance techniques and tools, such as security cameras. Of course, there will be litigation about what counts as a conventional surveillance technique and tool. We'll see. And of course, the court left open the possibility that the government could still get cell site information for under a week. There will be litigation about that, but if the government could get it for, say, 6 days, it's possible that that will fill in part of, mitigate some of the damage to the government and its ability to investigate some crimes.
And Michelle, what does this mean for privacy and civil liberties?
Well, I just can't be more excited about what this means for us, and so happy that we're here under good news and not bad news, right? I think a ruling that would have just across the board held up the third-party doctrine would have been devastating to our work. But as far as the litigation is concerned, it does give us a roadmap of how to be successful in the future and challenge different types of technology. I think it's interesting that it was actually the government for many years, especially after 9/11, who advanced the mosaic theory. Of course, this was on the idea that they didn't need a warrant, but what they told Congress and others is why they needed so much information is that when you put it all together, all these disparate dots that don't seem to mean anything by themselves come together and provide a meaningful picture of something, right? And the court embraced that, and this is, I think, really just a monumental thing for us. I guess we'll talk more about sort of what we hope is next, but I think it also helps us reconceptualize what is maybe most important to a certain type of people who are making these decisions, right? It was interesting that we often talk about privacy as collection on information on innocent people, and we're most concerned about maybe broad requests on people who don't have individualized suspicion, and the court here was really interested in long-term tracking of sensitive data on a single person. And so we will have to be thinking about how that affects our legal positioning. But I think it also, for our field, rejuvenates our work in the legislative space with not just the federal, but locals and states where we've had more luck in the privacy area. It is definitely something that strengthened our hands, right? It was always considered a political issue, something to take on law enforcement or intelligence. To have something like a Roberts, right? This opinion is going to give some validity to this argument that I don't think we all had ourselves just as an advocacy community.
Now, Evie, I think Dan sort of previewed this answer, but I would love to hear procedurally and in practice, what is this going to mean for law enforcement, particularly with regards to other types of information that they may now try to obtain instead?
Well, if I could, let me just say that, and I was talking with my colleague here, you know, cell site information is interesting, and most people hear about cell site information as incriminating information in a criminal case, that it's used by the prosecutor to prove that somebody was in a general area or an area of a place at the time that a crime was committed. But the same argument could be made that if cell site location information is in the hands of the defense and prove that the defendant was in a different state at the time of the commission of the crime, then that's exculpatory information. Now, I will point out, and it's a small point, but I will point out that by requiring now a search warrant for the, to get cell site location information in a particular case by the prosecution in most cases, that it's going to be an impossible procedure for the defense to get their hands on this, unless the prosecution or the police department does it for them. And I will also point out that by the time that comes to fruition, we may be looking at, depending on the state that you're in, anywhere from 30 days to a year down the road, and depending on the retention periods of that information by the cellular provider, that data may or may not be there when the defense requests it. Even if the government and the law enforcement folks say, okay, we'll go get it for you, it may not exist because there is no national standard for the retention of data by these cellular providers, and so it is a little bit of a hit or miss situation. So when law enforcement seeks to get the information, for obvious reason, they try and get it right away. But now we have to stop, take a deep breath, and say, listen, you know, in most cases, do we have probable cause? Do we have enough now to get a search warrant? And by the time we get there, is that data still there? Is it still useful? And if not, it's gone forever. And so I just want to point out that small point that it can be both incriminating and exculpatory. A second practical point with the requirement now that we get a search warrant is that we are so used to hearing about federal government search warrants. You know, somebody in the Eastern District of Virginia, the U.S. attorney can go get a search warrant, and he has the ability to send it nationwide. Well, if you're not in a state operating under Virginia law or in a state that has a long-arm statute, if you're in a state in this country where your state law does not authorize the local prosecutor or law enforcement to get a search warrant that is then served on a provider in another state, what is a local prosecutor supposed to do? Back before Virginia passed our own long-arm statute that gave us that authority, I remember one time when I had to get a search warrant for this kind of information from a cellular provider in New Jersey. And so we prepared the search warrant. It was signed off on by a judge, but we couldn't serve it in Virginia. So we just forwarded it up to New Jersey and asked them if they could please, the prosecutors in New Jersey, please go to their judge and see if he would enter a New Jersey search warrant to ask the provider for the same information. And the judge in New Jersey said, not doing it. I'm not the cellular provider judge. I am not going to do it. So Virginia was left twiddling their thumbs with no apparent ability to get information from a cellular provider. That's the kind of issues that confront states and localities when they're trying to get this information through lawful process. I'd also point out, too, that interpreting this decision, I have 3 trial judges. Arlington, for most of you are locals, I suspect. Arlington is a community of about 250,000 people. We have 3 trial judges that would rule on this issue. Looking ahead, I think maybe I would get 3 different opinions about what Carpenter means. And if you multiply that by the number of trial judges across the country, I suspect you'll get thousands of different interpretations of what Carpenter means. So what do we do with that? We're going to have litigation for years to come. Nobody's going to have a real answer on whether or not 5 days of cellular cell site information is something you can get without a warrant or not until the Supreme Court again weighs in on this. So the uncertainty of that makes this very difficult from a local prosecutor's standpoint. And finally, I just want to point out the irony of the third-party doctrine in Carpenter in the sense that I've done financial crimes for decades, and I think I get actually more information from financial records than I do from cell site location information. Credit cards tell me where you've traveled, what you've bought, when you've done it, where you've been for the most part. There's a whole lot of detailed, intimate information in credit card and banking information that Carpenter now says is fine to get with a subpoena under the third-party doctrine. So I find the distinction a little bit between the privacy interests in your physical location and your privacy interests in your credit card records and the details that we get from that kind of information to be troubling.
I believe Justice Kennedy made a similar point in his dissent. David, I want to direct this next question at you. I noticed that Google joined an amicus brief with Apple and other big tech companies that said that they weren't taking one side or another in this case, but nevertheless spelling out a vision, so to speak, of what the Fourth Amendment should look like in the digital age. So I was wondering if you could talk about that vision and also explain why do cases like this matter to big tech companies?
Yeah, so I think when we filed the brief with a number of other technology companies, we filed it in large part because we believe that the third-party doctrine should not categorically foreclose Fourth Amendment protection for data that's automatically generated by the use of a device or for data that's generated by activity, devices, and services that have yet to be discovered and or invented. And I think the court agreed that there are limitations to the application of the third-party doctrine in the context of certain types of transactional data, in this case the collection of cell site location information over a period of 4 months. And what the court concluded here was that this type of data is qualitatively different, that it is a different species of business records, as they said. And that I think it's becoming increasingly clear that the third-party doctrine is ill-suited to address the types of data that is collected and used in modern-day life. I think the court had made an observation that venturing into this public sphere merely by the use of a cell phone, which is collecting location information merely by its use, doesn't extinguish the Fourth Amendment rights that an individual has in the data that's being collected. I agree that some of the distinctions here are unsatisfying ones. I think that's a function of the fact that the third-party doctrine originated under cases where we couldn't envision where technology was headed. And so the court, rather than disturbing the third-party doctrine, overturning it or jettisoning it, was trying to render a decision that created some consistency and some predictability. But it's hard to envision a scenario other than saying that the third-party doctrine rigidly applies here, where you wouldn't have at least some outstanding questions about where the courts are headed with these sorts of cases and the particular facts and circumstances that may shape future decisions. From a practical perspective, I'll just say, we collect location information. It's different than cell site location information. It's more precise. We've always required a warrant for that type of information. From a practical perspective, I'm not sure that a lot is necessarily going to change, at least in that vein. If you look at our last transparency report from, I think, the second half of 2017, we had 16,054 requests. We break that down further into warrants, subpoenas, and what we call other court orders. That will encompass the type of 2703D orders that were the subject of the Carpenter litigation. I think we got 1,334 of those requests. I think it's natural after a decision like Carpenter that we're going to be reassessing our protocols in light of what the court said. But there are outstanding questions here. There, as Justice Roberts noted in his majority opinion, this is a narrow decision. It was rendered in the context of collection of cell site location information over a 4-month period. So there are outstanding questions, I think, about the episodic collection of location information, other types of information that may have some bearing on some of the Fourth Amendment issues that we're discussing.
Yeah, that's a perfect segue into what I wanted to talk about next, and that was the fact that Justice Roberts literally had a laundry list at the end of his opinion about what this opinion is not supposed to do. He specifically said this opinion is not meant to discuss real-time collection of location information. It left tower dumps alone, expressly did not overrule Smith or Miller, did not apply to conventional surveillance techniques such as surveillance cameras, or conventional techniques involving foreign affairs or national security. And of course, as both Dan and Evie have pointed out, there's a question as to length of time of surveillance of location data. So my next question to all of you is, was this case really a big deal?
Well, I won't deny that it's a very important case, and it continues a series of decisions by the Roberts Court that recognizes and affirms that the Fourth Amendment is going to be analyzed differently when we're looking at new technology. But it's certainly conceivable that when the court ultimately reaches those issues it didn't reach, the real-time tracking, cell tower dumps, metadata, that it's possible they will in the end rule for the government there, and we might look back 10 years from now and say it wasn't that big a deal. It certainly, I think, has the potential to really affect the government's ability to use this new technology. So let me give one thought on how I think we're going to go about assessing these future cases, and then if you think it'd be useful to maybe give some thoughts on what I think the court might do. So it's hard, as I think David was suggesting, it's hard to predict what the court's going to do in these future cases based on the nature of this opinion itself. There was no bright line drawn. it was, and I don't mean this to be critical, but I think the nature of the Chief Justice's opinion was it was judging like a common law court, using sort of the court's, the justices' sensibilities and intuitions about how far was too far in terms of our privacy. And I suppose if the test is what's a reasonable expectation of privacy, well, what we're asking is 9 justices to give their sense of what members of society would think and what we think is reasonable for a member of society to think in this new high-tech age. There aren't bright lines on that. We could draw analogies. We can just give our sense, and his sense, to the 5 justices, his sense was that, boy, getting 127 days dating back years, and we're getting, they said we should really take into account what the technology is today, where you really can find out where the person was in a pretty tight area. That's too much for us. The dissent had a different view, and whether they will view metadata the same way, whether they will view a cell tower dump, which is different on a couple of axes, right? It's a shorter period of time. You basically, as I understand it, and you all probably know the technology better than me, they take a couple of cell towers, they say, we're going to look at all the calls that were made there for a short window of time, and then see if we could find numbers that were at both sites, which might help them link who might have committed who might have been the robber who committed both robberies. So it's a shorter period of time, but it's getting information from non-suspects. Maybe they'll view that differently, maybe not, and I don't think you could read a definitive answer from the Carpenter decision. So not to go on too long, let me just talk a moment about real-time tracking, which I gather is through devices like stingrays that allow a law enforcement officer to basically mimic a cell tower and intercept calls. So you go to, I guess, a location you're targeting, and then you'll be able to determine who's making a call from there. My sense, as someone who follows the court closely, is that the facts of the case, as it will ultimately reach the court, would matter a great deal. Was the law enforcement officer using that to find out what the phone number was on a call that was from a house? In which case, I think they might be deeply troubled, thinking back to their Kylo decision, where they said the police can't use thermal imaging detectors in homes. Or were they using the device to find a phone number that came from a public place? How long was the tracking? Was it for a few hours? Was it for a few days? These facts matter a great deal, and I think we saw that in Carpenter. The ACLU was very smart in the case they took to the Supreme Court. It was a case that involved 127 days of where this person was. What if the case that made it to the court involved 3 days of tracking or 3 hours of tracking, the hours that were around 3 different crimes? There's a pretty good chance the government would have won and would be here with a very different tone, would be saying, all right, well, the government won this narrow one, but they left open the case where it's longer. So the facts, sometimes people think that facts don't matter in the Supreme Court and that they're just deciding these very academic legal issues, but the nature of the case that makes it to them matters a great deal, and I suspect that will matter when the case takes up the next series of issues involving high tech.
Michelle, I want to turn to you because another focus that Justice Roberts has was on the voluntariness issue and how voluntary is it really when your phone is constantly pinging the cell towers around you without you actually doing anything at all. What could that mean going forward when courts try to interpret this case?
I think that was one of my favorite parts of the decision because I felt like it pushed us 40 years forward from where the last decisions were about what voluntariness means and understanding that technology is not a luxury anymore, right? It's not something voluntary, that these things we use now in our schools, at work, to get around, to communicate, to buy things, and that you can't expect people to basically live in a cave to, exercise their privacy rights in the modern day. And so I felt like the voluntariness and reconceptualizing it that way, instead of just saying, well, you choose to use this knowing the consequences, really put this into a different light. And I think that's why it's still a big deal. Like your last question, I think there'll be uncertainty, but if you talk to impact litigators, they will tell you that all the rights that we have now actually took decades of litigation to secure, right? And it feels like a very long time now, but this is actually just a small moment in how technology has evolved and will continue to evolve. And so we'll just have to figure out where the rest of that goes. The other option too is if prosecutors value their certainty more than the residual benefits of, let's say, 6 days or less, or prospective tracking, they can make the affirmative decision now to get warrants as opposed to using lesser orders in some of these areas where the court did not weigh in.
Well, I want to keep talking about the fact that Justice Roberts really focused on the sensitivity of the location information itself, because doing that really left open a lot of gaps and ambiguities for my firm's surveillance law practice to just figure out. So was he right about the sensitivity of location data from your perspective, Evie?
Well, I'm looking around this room, and I think I'm on the older side, but to put it into perspective, when I started in 1990, I didn't have a cell phone, I didn't have a laptop, I didn't have any of the bells and whistles. If I wanted to call a friend, I'd use my landline. If I wanted to communicate with them otherwise, I would write an actual letter. And technology has grown so quickly. But we're at this place, we're at this intersection right now where privacy interests are we're weighing them like this, because what does everybody do? Everybody uses their technology for everything. Absolutely everything. And we willingly allow advertisers to, advertisers target us. We do get store cards. Our credit card folks know where we are. Our travel apps know where we are. Google Maps knows where we are. Everybody knows where we are all the time. We post on social media sites, oh, I'm at this restaurant. Look at what I'm eating. It's awesome. We're post happy. We share more information today than I've ever seen. So people are more willing to divulge more intimate and detailed information about themselves than ever before. And I put that out there simply to say, should that fact not inform our privacy weighing? You know, how much do we willingly put out there and share, and then can we really complain about being overly sensitive about our physical location when I'm happy for you and you to have it, but not to the police officer over there? I just point that out because it's an irony that is the case.
David, do you have a response to that? Do you feel like Google's users feel like they're voluntarily sharing all this information with the world?
Yeah, I mean, I guess I would make a distinction between information that you are voluntarily divulging. For example, you know, Twitter, which is a very public platform that you are putting out there for the world to digest, versus information that's being automatically collected by a cell phone, in this case, cell site location information. And then there are variations and gradations in between. A citizen's reasonable expectation of privacy may differ depending on how public that information is and the extent to which it's being sort of voluntarily conveyed. I also am a little bit fearful about the way that the decision was crafted, in that, again, if we were thinking about a Fourth Amendment doctrine for the internet age, we wouldn't start with the proposition that we should be thinking, I think, about whether information is provided to a third-party service provider, full stop, whether it's voluntarily conveyed to that third-party service provider, and then whether there's an assumption of risk as a result. I don't think anybody thinks of their privacy that way in 2018. But based on the court's decision, it seems that in some ways, transparency, awareness, even privacy settings have some bearing on a citizen's Fourth Amendment protections. So that is a little bit of a concern. The good news is that there are a lot of these issues are actually ripe for policy consideration and policy debate. That's why it's great to see so many of you out here today. The courts are going to be grappling with these issues, but the extent to which some of the more meaningful discussions around the practical implications of the court's decision, the extent to which the Supreme Court reaches those issues, they may reach a couple, they may reach a few over the next decade. In the meantime, there's a lot that Congress can do to address whether the statutory protections under the Stored Communications Act ought to be modified in light of what we know about these technologies and the reasonable expectation of privacy, not from a constitutional perspective, the reasonable expectation of privacy that users, I think, believe they have when they're providing this data to a Google. In the same way that when you are storing data on your own device that isn't transmitted to a third-party service, your expectation is that data is private. The notion that there should be strong distinctions between how either the Constitution treats that data or how Congress does, or our laws, whether at the federal or state level, isn't entirely clear, at least to me. So.
Michelle, I believe you had something to say too.
Yeah, and I think this is the importance of making this a constitutional ruling, is that, your rights are not use it or lose it, right? They're yours. You get to use them or not. You can even exercise them in incredibly stupid ways, but that's why it's a right and not a privilege, right? And so just because you choose to share some information with people and not with others under certain contexts, that's your decision to make, right? It shouldn't change your relationship with your government. And that's what this is about. This is not about how you use Google. This is about what the government has to do to collect information on you when they want to put you in jail, okay? And those are very different stakes. We've been critical, too, of how the companies collect this information, but we can't say that just because you choose to share information about your sandwich, that the government can now track you for months at a time and know everywhere you go, right? Those two just do not connect. And that was the beauty of this decision. I think they recognized that just because you choose to use technology doesn't mean that you opt into government surveillance.
Well, I definitely want to leave room for questioning, but because there were 4 dissents in this case, I think we'd be remiss if we didn't talk about at least some of them. Preparing for this panel about 5 days ago, I really wanted to talk about Gorsuch's opinion, and I still do, because Justice Gorsuch clearly indicated he is not at all a fan of the third-party doctrine, yet he appears to want to revert back to more traditional Fourth Amendment jurisprudence in the form of property-based rights, for example. Now, of course, we have to talk about what Justice Kennedy's departure will mean for future Fourth Amendment cases. So I don't know who wants to take this question first, but
well, I could start off with it. So like many other criminal procedure areas, the Fourth Amendment was an area where the court was not dividing cleanly among the conservatives and the liberals, putting to the side the exclusionary rule when it came to issues of was there a search and other related issues of, was the amendment violated. When Justice Scalia was on the court, the pattern tended to be you would have the 3 of the liberals on the court, Ginsburg, Sotomayor, and Kagan, and Justice Scalia would generally be on the side of the defendant, saying there's not a search. On the other side, you'd have Roberts, Alito, and Kennedy, along with Justice Breyer. And Justice Thomas was a swing vote. It's one of the rare areas of the court where Justice Thomas was a swing vote. Now, Justice Gorsuch replaced Justice Scalia. He seems to be similar to Justice Scalia in terms of taking something of an originalist view on the Fourth Amendment, and I think an instinct to be supportive of the defendant, though, as we'll talk about, it's not clear exactly where his property-based theory is going, but it seems to be even more defendant-friendly than Justice Thomas's property-based theory of the Fourth Amendment. So the replacement of Justice Kennedy is very interesting because, there's obviously a political hurricane going on now. Everyone's talking about abortion, gay rights, executive power. It's actually going to be fascinating to see where this nominee is going to be on the Fourth Amendment, and if there's enough of a track record to tell, because really, as we've seen on the court, there are 2 types of conservative justices when it comes to the Fourth Amendment. There is, and I know Chief Justice Roberts was in the majority here, so this case was an exception to the general approach I had laid out. And but generally, Alito, Kennedy, and Roberts had been sort of the law and order side, and you had Scalia and Thomas had been more of the originalist side, more willing to be for the defendant. So is the new nominee going to be more like Alito and, say, Kennedy, or more like Scalia, Gorsuch, Thomas? It will make quite a difference in a lot of these cases. Certainly, the defense has found a friend in Chief Justice Roberts in the Riley case on cell phones. In this case, don't be so confident you're going to get him in all the other cases down the line. He is generally a friend of law enforcement on constitutional cases. So I think this would be a very important and pick, and we really don't know who the new person. We can't pigeonhole that a Republican nominee to the court is going to be one way or the other on the Fourth Amendment.
Anyone else want to venture a guess?
I don't want to venture a guess, but I do think this was a really interesting dissenting opinion, in part because if you didn't know it was a dissenting opinion, you might have read it as a concurring opinion, and it was really but for the theory that was advanced by Carpenter that Gorsuch came out on the dissenting side. I mean, he said that in the closing part of his dissent that that property rights theory hadn't been advanced, and even was only advanced, I think, in a cursory way in the brief to the Supreme Court. I'm not a litigator, but if I'm a defendant in a future piece of litigation, I'm making sure that I'm making both of those arguments just to be prepared in the event that this works its way up to the Supreme Court. It seems to me that defendants are going to be raising both the reasonable expectation of privacy argument and a property-based theory in whatever records a third-party service provider might be holding.
Well, because we're here on the Hill, I would love to talk about what, if anything, Congress should be doing next. We had a preview of some suggestions from David earlier, but Evie, I would like to hear from you, and then you too, Michelle, perhaps, about how can Congress respond to this case in a way that would help law enforcement, or in a way that would clarify things from a privacy and civil liberties standpoint.
Well, I certainly think it's about time that the Stored Communications Act is finally updated. It's been, I don't know how many years since it was passed. It's outdated. The definitions are poor. And I really think, from a prosecutor's standpoint, I want clear definitions. I want clear guidance. I want to know what I can do and what I can't do. And then, so Congress needs to step in. I need to know what data is protected, what data third-party providers need to retain, how they collect that information, how long they retain that information, and how it's preserved. We need longer retention periods for this data that is accessible via search warrants, if you will, but we need to have the ability to access the data in a consistent manner. So I would ask and beg for Congress to step into this arena and produce some legislation that is uniform, that applies across the country, that states then can take and model with their own state statutes, that locals and state folks can follow faithfully. That's what I ask for.
And I would say, to me, the next obvious step is around the prospective location tracking, especially if you want to stay in this sphere. So I think if you wanted to regulate not just SCA, but also the prospective tracking, you could better handle similar issues at the same time. I think forward-looking, though, of what other things that are likely to be challenged but also need your attention because they are sensitive, are things like facial recognition. I think that was one of the first things to be taken on because it will be a voluntariness issue, right? The majority opinion talked about, you don't lose your rights just as you step outside of your front door. And talk about facial recognition, that's what happens, right? The minute you step outside, you're now available to the world with your biometrics. And I don't think we know yet just how much law enforcement is able to collect or where it's going, what it's going to look like in a couple years here, but it, I think, is one of those areas that is going to be targeted early on. And I think, this is also a chance to think about things like internet records themselves, because I think this is sort of a niche, or if you want to triangulate sort of like the importance of the phone itself and everything in it, voluntariness, longitude. I mean, next thing is what's on that laptop, right? And what comes off of it. And in many ways, they're just as sensitive as our cell phones. So I think those are some areas that Congress could look into.
I agree with Michelle wholeheartedly that if they take up stored communications and redefine terms, they also have to take up the wiretap law and the pen register trap and trace law, because they all carry similar definitions across, and technology has changed so much that technology that fit into one niche under the Stored Communications Act may now be obtainable under pen register, or you might need a wiretap for it. So everything has changed the way these particular laws are applied, and so it's pretty urgent that they need to be updated.
Just want to add, there's also lower hanging fruit here too. The court and even the majority and the opinion and even Justice Kennedy in dissent sort of glossed over the case that I was alluding to before, which they referenced, the Warshak case, and the fact that your email content is sort of the modern day papers and effects, and we've seen Congress addressed this issue repeatedly now, 2016 and 2017, and now in the National Defense Authorization Act. That's the Email Privacy Act, the piece of legislation that would codify a warrant for standard, and that would get rid of the current 180-day rule where an email communication that is over 180 days old can technically be subpoenaed. And I think what the court was clearly suggesting both here and in its previous decision in Riley is that to subpoena emails would be unconstitutional. But that rule, that unconstitutional rule, is effectively still on the books. But there are also broader policy reasons, I think, for a company like Google to have a rule that requires the government to obtain a warrant for communications content, regardless of who the individual is. The Fourth Amendment applies to U.S. persons. It does not extend to those that are outside of this country. Congress did actually have a revision to the Stored Communications Act earlier this year with the Cloud Act. They talked about obtaining content when seeking data about non-U.S. persons, and they built a warrant scheme around that idea. But they kept in place the existing 180-day rule. There's a theoretical possibility that data about non-U.S. persons can be subpoenaed under the Stored Communications Act. We should have, for the purpose of administrative feasibility and management, a uniform rule that codifies a bright line warrant for content standards. So I would encourage those of you who are working on this issue and have in the past to continue to push forward this. It is in the National Defense Authorization Act that will ultimately need to be reconciled with the Senate's version, but there's still an opportunity in this session to realistically update ECPA.
Well, we have some time left. I want to open up the floor for questions. So if you have a question, just feel free to stand up, try to speak loudly so that our microphones can pick it up, and I'll call on whoever I see first. Greg?
My quick answer is I don't know, but let me give one, I think, important legal gloss to that issue, which is the court held in a case called Davis against the United States a few years back that the exclusionary rule doesn't apply if evidence was obtained in reliance on what the officer reasonably thought was existing law. Say circuit precedent said this type of search was okay. The court hasn't definitively held whether, but I think there's a pretty good chance 5 conservatives would agree that the exclusionary rule shouldn't apply if the law is unsettled, but the officer reasonably relies on a reasonable interpretation of the law. So let's say an officer is deciding whether to obtain without a search warrant 3 days of cell site tracking. I think there's a pretty fair chance that if it made it to the Supreme, and that if ultimately that was held to be unconstitutional because it's a search and you needed a warrant, that until that is definitively determined by the circuit or the Supreme Court that the exclusionary rule wouldn't apply because the officer acted in good faith and acted reasonably and not in dereliction of his or her duty. Now, that said, I think Evie, who works on the ground, will say, I'm not sure I really want my police officers in my jurisdiction doing that because it's too risky. So
No, they're going to get a search warrant.
Yeah.
Regardless. There may be from time to time a case where we are not entirely sure that we have probable cause. We're just there and we don't know if we'll get there. In that case, we may do a day or two with a court order and see. But I got to tell you that I haven't done a court order for cell site location in probably 2 years. Because our officers go straight to the search warrant. So a court order you can get it with reasonable articulable facts, which is a lesser standard than probable cause. And when ECPA and the Stored Communications Act was first passed, that lesser standard applied to transactional information that you could get with what federal law called a 2703D order. Most prosecutors interpreted that law to mean that we could request historical cell site location information under that lesser standard, if you will. And so we would prepare in our office a court order with an affidavit that the police officer produced. We'd hand it to one of our trial judges, and they would agree that we had reasonable articulable facts, sign the order, and it would go off to the cellular provider. They can get that same information with a search warrant. And for a number of years, that's exactly how they have been proceeding. So in Arlington, from a practical standpoint, unless a case is just not quite there, and the only thing that we can get to either confirm the commission of a crime by a particular person or dispel that belief, we're going to go for a search warrant. Otherwise, we might risk a D order, as they say, but I would be really reluctant to go down that path.
Anyone else? Yes.
My name is Maurice. My question is directed toward Michelle. Perhaps have you mentioned previously that there might be a scenario where a defendant may not have access to data prosecution doesn't request. So my question is, what right should an individual have to actionable data about them and use they voluntarily provide to a certain?
So, I mean, I can say just from Google's perspective that the data that was, at the heart of the Carpenter case was data that I don't believe was readily available to ordinary users. The type of location information that we collect is available, and so it's something that users could access, they could produce on their own. I imagine there are also scenarios, too, in a situation where you have a defendant who doesn't want that data produced, maybe because it's inculpatory, they're not going to be cooperative with law enforcement. In situations where that data is exculpatory, they will consent. It will obviate the need to obtain a court order or search warrant. I think the question just is whether that data is readily accessible, how easily it can be produced, and what the legal avenues are. But I think, it will depend on the data, the provider that's holding it, and the extent to which really the privacy settings enable a user to access that data.
Yeah, and I think almost every privacy law in the books has a consent exception. So the, I don't know if you want to call them the data subject, can't agree to have the information accessible. So I don't know if the issue is that they can't compel it is the problem, and maybe some companies would not allow that. But yeah, and I think this is also, just something that is going to be changing right now with GDPR, discussions in this country about rights that people have vis-a-vis the companies themselves, and hopefully it will be evolving into an area where people do have more access.
Yes.
Hi, Max Billion. You mentioned earlier that this ruling won't really change much about how Google responds. I was wondering if you could just
Yeah, and I was answering that question in the context of just location information that we do collect because we do require a warrant for the production of location information. I think for other types of requests that we might receive in the future, I think we're going to have to look at historically the types of requests that we've received, the types of data that we've been asked to produce, for example, under 2703D. The fact that I think we didn't talk a lot about this, but that the court really did draw a pretty big distinction between what's required when they seek a 2703D order versus what's required when they obtain a search warrant under ECBA. So I think, right, we're a week out from the Carpenter case. It's really difficult to sort of discern how our compliance protocols might be modified as a result of the decision. But I also think, too, at least from from experience, we found, I think, as Evie was alluding to, too, law enforcement officials are increasingly cautionary, and they obtain search warrants to the extent that there is ambiguity. So we haven't run into these types of problems, I think, as often maybe as others have.
Yes.
This is just closer on the U.S. version of the GDPR, or you do it for clarifying the hands of.
Well, the GDPR is your rights against the company, whereas this is your rights against the government. And I know in the U.S. we've always kept that very, very distinct, right? So I don't know if it necessarily follows. I think there's already interest in the U.S. on rights vis-a-vis the companies. But I think as you see more of these cases where it comes into people's consciousness, facts are gathered, right? I think this was maybe one of the first cases because we know so much more about cell phones than we do about some of these other technologies, right? That I think they do contribute to each other, but it's not a one-to-one relationship.
I believe that's all the time we have, but thank you all very much for coming, and please do continue to check out this ongoing series of SCOTUS Tech, and I'm sure they'll have some great events coming up in the future. Thank you very much.